Mr. Meineke, you here on TNT Financial?
Yes, that's correct, Your Honor.
All right. Right, we're on the record in docket 20-00333. That is TNT Financial versus Nicole Bell. Will the parties please introduce themselves for the record?
Good morning, Your Honor. James Meineke appearing on behalf of the plaintiff TNT Financial.
All right, and this is set for, I have it. This was your objection to their motion to set aside installment payments. Is that correct, Mr. Meineke?
Yes, that's correct, Your Honor.
All right. This was scheduled for 8:30. It is now 8:50. It would appear that the Nicole Bell or the defendant has failed to appear to answer the objection to their motion to set aside installment payments. This was scheduled by Ms. Bell concerning the date of judgment of $9,768, and then she wanted to set that aside. And I think she wanted to set aside the writ of garnishment. Is that correct? And then she wanted to pay $25 every 2 weeks.
That's correct, Your Honor. This would be actually the third order for installment payment she would have received. The last one was set aside in December. We didn't put that in our objection. But yeah, she was looking to pay $25 biweekly. TNT objected that the balance is just too small. The payments are too small and would not cover post-judgment interest.
All right, so it appears the defendants failed to appear. I'm assuming you want the default judgment in regards to the motion, and you want the court to deny the motion to set aside the installment payments.
That's correct, Your Honor. We'd like her to object her motion for a request for an order for installment payments.
And you'll follow that up with an order to that effect, or there's an order here. It's order on motion to set aside order for installments payments. I can just deny that motion as part of the order.
That's fine, Judge. I think that works.
Okay. Yeah, so it's order on motion to set aside order for installment payments. I could just check the motion's denied, and I could say because the defendants failed to appear, the order, the default on the judgment has been admitted, and that probably expedite this a little bit.
I think so, Judge.
Okay, so order denying motion to set aside judgment will be signed. For the record, I've checked the Zoom courtroom. I've checked the physical courtroom. Mr. Milks just came in, so that is not Nicole Bell. And so I will sign the order indicating that the motion is denied. 3/24/2023, and I'll sign that order. And Mr. Meineke, you should be all set today.
Great. Thank you, Your Honor. Have a good weekend.
All right. Thank you. You too. That's all for the record, docket 20-00333. Mr. Milks, you're here on Miss Brown.
So with Ms. Brown, we have a conflict.
Right. That's what you indicated today.
I believe we got,
and then you're here on Mr. Robart.
yes,
Okay.
9:30, I believe. He's downstairs up there. Or
Yeah, he's downstairs. He's in lockup. Polycom.
Perfect.
So.
Yes, so just to follow up on the Brown, Your Honor. I don't know if you wanted to put that on the record or if that's
With Mr. Milks here, we can just put it on the record, indicate that.
okay, because Mr. Yang's here as well.
Is he?
Yeah, he's in the building. He's got a
exam somewhere
at 10, I think. So.
Whenever he wants to come in, if we're around, I mean, we should be around. We can put it on the record.
Okay.
Just for. posterity purposes. I mean,
Okay.
I think I signed the substitution yesterday that,
Yeah.
that hasn't come in yet.
No, I think
Should
you
go
said
soon.
it hasn't been entered in their file.
I guess we could
Okay.
just leave that
But-
on for prelim. I don't think we have to put it on the record, but.
He may ask for an adjournment, maybe that's.
Yeah, that's what I'm.
When we spoke here in the courtroom, and like I said, if you want him to come and verify it, he can, but when we spoke, he was just saying right now, leave it on for prelim, and then if he needs to waive the 21 days, we can do that next week.
All
in
right.
Prelim.
Well, let's just leave it on then. That's just, I think that's Ms. Brown. I'll just indicate per defense and prosecutor, leave on for prelim. And Mr. Abbott, you're here on Kelly, on all those Kelly files.
Jacob Kelly, right? He's got a PCC today.
Yeah, I've got him for a PV arraignment, a violation of probation, and a probable cause hearing.
Okay,
Does that sound right?
it makes sense, yes. Under the circumstances.
And so, and Mr. Kelly's here.
Your Honor, the prosecuting attorney's made an offer on the new felony case, which if we accept, we'd like to accept the offer, which would probably be a violation of his probation.
Right. Mr. Abbott, I'm trying to figure out the easiest way to. I've got an arraignment file, and I'm trying to figure out if that arraignment file is due to the arrest, or I also have a pending violation for testing positive, which may have come after he was arrested on this file.
Naturally, Your Honor, I haven't discussed either of those with him at this point.
Right, so let me get the probation agent up here, and then I might place you in a breakout room with Mr. Kelly, so he can, and just so he knows what's coming at him.
Okay. Your Honor, I have a
And then-
PCC I could handle in Judge Buchanan's court if you've got a
Why don't
minute.
you go ahead and do that and then come back?
Okay, thank you.
All right, Mr. Kelly, stand by and we're just making sure we have all your files together. So we're on the record in docket 23-00782. People of the state of Michigan versus Javier Diaz. Will the parties please introduce themselves for the record?
Jeff Product on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Derek S. from Office of the Public Defender on behalf of Mr. Diaz, who is standing to my right.
And sir, you are Javier Diaz?
JV Diaz.
Javier Diaz?
Yes, sir.
All right. And Mr. Brodowitz, this is the time set for a probable cause conference. How are we proceeding?
It is my understanding, Your Honor, that the defense will be waiving the preliminary exam. The people have made an offer of pleading guilty as charged, and then the defendant can apply for HYTA if eligible.
Is that an accurate statement of the negotiations, Mr. Etheridge?
Yes, Your Honor. The only thing I would add is with negotiations to continue upstairs regarding a sentencing agreement.
The negotiations to continue. Mr. Etheridge, may I inquire of your client of his waiver of the preliminary examination?
Yes, Your Honor.
Okay, you've heard the attorneys talk today, sir? So you understand on this felony count, the offer is to plead as charged. You'll apply for 769 for a status, and then will it,
HYTA.
I'm sorry, HYTA. What did I say? 769 for
Yeah.
HYTA status, and then you'll seek that availability and negotiations are to continue on this file. Do you understand that, sir?
Yes.
You understand you have a right to a preliminary examination within 21 days of your arraignment. Your preliminary examination is scheduled for March 31st, 2023. This is your probable conference of March 24th, 2023. And at that probable cause conference, you'd have a preliminary examination in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, Your Honor.
You, of course, are represented by Attorney Derek Etheridge from the Public Defender's Office, and he would be present to contest any charges and cross-examine any witness brought against you in your defense. Do you understand that, sir?
Yes, Your Honor.
It's my understanding you wish to waive your right to preliminary examination. That will end your time in district court. You would go to circuit court where the case would continue. The offer's been made and negotiations would continue. Is that correct?
Yes.
Is it your wish today to waive your right to a preliminary examination?
Yes, sir.
All right. Do the people also waive their right to a preliminary examination?
Yes, we do, Your Honor.
I find the preliminary examination waiver to be knowing, voluntarily, and accurately made. And I will waive this file 23-00782 from district court to circuit court where the case will continue. Please keep in contact with your attorney, Mr. Etheridge. He'll give you your next date in circuit court. Since we don't give it to you here, your next date in circuit court for you to appear. All right, sir?
Yes, Your Honor.
All right. And you should sign the waiver. All right, let the record reflect that I'm signing the waiver that is indicated and signed by the parties. Anything else for the record in docket 23-00782, Mr. Brodowitz?
Nothing from the people. Your
Anything
Honor.
else, Mr. Etheridge?
No, Your Honor, thank you.
All right, Mr. Diaz, your time in district court is done. All right, sir?
Thank you, Your Honor.
Thank you. And then Mr. Yang, on Miss Brown, we just left that on.
Yes, yes.
Is
Your
that
Honor.
right?
Correct. I just want to
Okay.
make sure you didn't need
Yeah.
to place anything on the record.
No.
Ms. Brown is president. so-
All right, we put it, we were gonna put it on the record and then we decided we'd just leave it on because that's what the parties agreed upon.
Yes, okay,
All right.
thank you, Your Honor.
All right, thank you. Brendan, come on up here and. We have Mr. Judge, yeah, we have Mr. Kelly here on a prelim. And then we have your probation violation. Is the arraignment on the, on the test, that's the arraignment, okay? Sir, person on the iPhone, would you identify yourself, please?
Jacob Kelly.
Thank you, Mr. Kelly. I've got you named, so I know. Who's the other person on the iPhone?
It's Joseph Kelly. This is Dad.
Okay. All right, Mr. Abbott's gonna be back. He's in another courtroom. I might place you in a breakout room so you can discuss. There's several files here, so stand by, okay?
Your Honor, we're ready to go on.
Mr. Abbott. I've got a Rainier guy on a file. And I understand you worked something out. It would probably be best if we just left it on for prelim and did it all at once.
Okay.
That way, we've got him arraigned on the PV. We've got the probation hearing. You okay, Mr.
Sorry, an individual does not smell
Okay.
pleasant.
I showered, I swear, Your Honor.
So.
All right, so we're on the record in docket. It's a ticket 22L2726163. This is a show cause concerning a outstanding balance. And sir, you are Eric Spencer?
Yes, sir.
All right. Mr. Spencer, we previously have been here before. And there was an indication that you were to pay $100 within 30 days. If paid, we would administratively close the file. It didn't happen, so we're back in the show cause aspect of this.
I was trying to get it taken care of today, so.
If well, it's up to 228 now with the
Yeah.
late fees. Is that something you can take care of today?
I mean, I don't have,
Can you make a payment towards that debt and set up a plan with the sixth floor?
yeah,
So this is what I'm gonna do. I'm gonna knock this down to the original debt, okay?
okay,
So let's knock this down, but you gotta take care of it today.
okay,
Or at least get over there and pay what you can today and get on a plan.
yeah,
If you don't do this, we're just gonna end up.
yeah, I know,
like, it's just a cycle.
that's why I'd like to go ahead and
Yeah.
get it taken care of.
Or at
today.
least set up a plan, like whatever you can afford to get towards there. So I'm gonna indicate that D is to go to sixth floor window. And how much do you think you can pay towards the $145 debt? I'm gonna indicate that we're gonna put it at the original amount of $145. How much can you pay today?
I should be able to take care of all of it.
If you can take care of all of it, it'll be done.
Okay.
And you don't have to worry about this anymore.
Okay.
Okay. So D to pay $145 today. And you're gonna go right now?
Yeah.
Okay. I'm gonna put right now,
Yeah, we'll walk out the door and head there now.
and then that would suffice for debt. And Wendy, you're putting that on the computer for them? All right. So it's $145 debt. If you go there right now and take care of it, this will all be done, all right?
Okay,
All right. Any questions of me, Mr. Spencer?
no, sir.
I think we've made it. I think your plan is the plan we're working with, okay?
All right.
All right. That's all for the record in docket 22L2726163. Good luck to you, Mr. Spencer.
Thank you.
All right. And Mr. Nevskin, you probably know where to go, but he
Yeah,
can show you where to
right,
go. Okay. Is Mr. Abbott back?
I only see the other two.
So, Mr.
Yes.
Abbott, are you back? All
Yes,
right.
Your Honor.
All right. So we're on the record. First of all, we're on the record in docket 22-01940. And I'm going to do this arraignment first, and then we'll go on the record on the probable cause conference. Mr. Kelly, I'm going to arraign you on an outstanding probation violation. So I'll at least need, if you're able to, I'll at least be able to hear you, sir. Are you Jacob Kelly?
Yes.
Okay.
Yes, Your Honor.
All right. Arraigned on probation violation. We have a plan set up for this, and you're arraigned on probation violation. I'm going to tell you the nature of the probation violation that has been indicated against you. This is based on a request and summons for probation violation. It was filed by Brendan Hanna on March 17, 2023. It was signed. The summons was signed by a judge on March 2023. An indication is that you technically violated your probation by testing positive for fentanyl and THC at PATS on March 1st, 2023. Do you understand the nature of the probation violation that is the allegations that have been brought against you, Mr. Kelly?
Yes, Your Honor.
All right. You understand you have the right to be represented by counsel in this matter. You also have the right to have a hearing in this matter, to contest and cross-examine any witnesses brought against you in the probation violation. It's my understanding what we're going to do here in regards to, and you've been explained that to Mr. Abbott, is we're going to set this over with the other probable cause preliminary examination to be handled next Thursday, next Friday. So we'll put all the files together. Is that your understanding, Mr. Kelly?
Yes, Your Honor.
All right. So I'm going to indicate that we've set the probation violation hearing for
March 31st at 9.
March 31st at 9 o'clock. And there is a recommendation in regards to that hearing. I don't know, Mr. Abbott, you're brand new on the case. So, and I don't know if I don't know if you're going to represent him on the violation, but feel free to reach out to Mr. Hanna, or the court will show you what the recommendation is. Okay.
Thank you, Your Honor.
All right. And then, so then we're on the record in docket. So we'll move that hearing and that arraignment towards the Friday, March 31st date. And then we're on the record in docket 23-00781. That is People of the State of Michigan versus Jacob Kelly. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Jacob Kelly.
And sir, you are once again Jacob Kelly.
Yes, Your Honor.
All right, this is the time set for a probable cause conference. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. After conversations with the defense, we have extended an offer. However, I know with the parole violation or probation violation, issues, that there was some discussion of moving the plea to next Friday, the 31st as well. So I would leave to the defense to what they would like to do.
Mr. Abbott, is that your understanding?
Yes.
All right, so this is set for preliminary examination. If an offer has been extended, you can indicate that offer for the record.
Oh, yes, Your Honor. The offer would be for the defendant to plead guilty to reduced counts of attempted resisting and obstructing a police officer and reckless driving.
Okay, so it'd be that would be counts 3 and 4, right?
Yes, Your Honor.
So count 3 of an attempt R&O and count 4 of reckless. So that's the nature of it. We'll go through the PAC codes next week, but I know that our attempt R&O is a 1 year And then the reckless driving is a 92 day or 93 day.
Off the top of my head.
Yeah, I'm pretty sure it's a 93 day. But that would be the nature of the offer. And that's what we're moving. We're moving next week, next Friday, Mr. Abbott, for leaving this prelim to go with the other files. And that'll be the offer extended, and it'll be extended through March 31st at 9 a.m. In order to resolve all these cases.
That sounds like a good idea, Your Honor, and if anything changes, I'll contact the court and the prosecutor's office.
All right. So, Mr. Kelly, we'll make that, since the plan is to plead at this time, we'll make that a live hearing. So that's live on the 6th floor for preliminary examination.
Yes, Your Honor.
All right. All right, so we have a plan, gentlemen, on all these files. We'll readdress them on March 31st, 2023 at 9 a.m. So we'll leave the prelim on for that date, understanding there's been an offer extended. Anything else for the record in docket 2300781, Mr. Brodowitz?
And nothing from the people.
Mr. Abbott?
Nothing from the defense. Thank you.
All right, Mr. Kelly, we'll see you next Friday at 9 a.m. Okay, sir?
Okay, thank you, Your Honor.
All right, thank you. That's all for the record in 2300781.
Thank you, Your Honor.
Out of order. You're not.
SO. It's Polycom, isn't it?
Sure.
So, Mr. Milks, I think Mr. Robart is here.
Yes.
Did you need to speak with him? Are you ready?
I should be okay, I believe, unless he needs to speak for me. We already have a plan on this. We spoke previously.
Okay. So we're on the record in docket 23-00642. People of the state of Michigan versus Chad Lee Robart Jr. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Robart, who is present with us via Zoom at this time. Your Honor, if I may, I'm sorry, if I may just jump ahead real quick.
Sure.
Your Honor, I am ready to proceed today. I've had the opportunity to speak with Mr. Robart. I just wanted to make sure that Mr. Robart didn't have any immediate questions or anything that cropped up recently that he would need to talk to me about briefly.
Mr. Robart, your attorney's asking if you understand what we're going to do at this probable cause conference, or if you need to speak with Mr. Milks in a breakout room just for any purposes.
Yeah, can I speak to him real fast in a breakout?
Sure. I'll agree.
Yeah.
Thank you.
Yeah. All right. So, Mr. Robart, once Mr. Milks joins the Zoom courtroom, we'll place you both in a breakout room. Okay, sir?
Sure.
All right, we're back on the record in docket 23-00642. And Mr. Robert, you've had the opportunity to speak with Mr. Milk in a breakout room?
Yes, Your Honor.
All right. This is the time set for probable cause conference. Mr. Milk, how are we proceeding today?
Thank you very much, Your Honor. Your Honor, after having the opportunity to speak with my client regarding his rights to a preliminary examination, it's my understanding he wishes to waive his right to a prelim. I'm understanding that the people are also not objecting to this. As part of this, Your Honor, my client already has a pending matter upstairs in circuit court, and I've already been in contact with the APA, Ms. Maycomer, in that sense, Your Honor. So today we would just like to waive the prelim at this time.
All right, and then I would assume negotiations are to continue in circuit court.
That's correct, Your Honor. Yes.
And that's your understanding, Mr. Brodowitz?
Yes, Your Honor.
Mr. Milk, may I inquire, Mr. Milks, may I inquire your client of his waiver?
Yes, Your Honor.
All right. Mr. Roberts, Mr. Robert, you understand you have the right to a preliminary examination in district court. That preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the identity of the person who committed the crime in this file and the probable cause to believe that a crime was committed. You understand that, Mr. Robert?
Yes, Your Honor.
Okay. And you, of course, are represented by attorney Mr. Milks from the Public Defender's Office, and he would be present to cross-examine any witnesses brought by the people against you and contest any charges brought by the people against you. Do you understand that, sir?
Yes, Your Honor.
You've heard your attorney talk along with the prosecutor. You understand that it's my understanding it is your wish to waive your right to a preliminary examination today and have negotiations considered in circuit court. Your time in district court will be done. Is that your preference to waive your right to a preliminary examination today?
Yes, sir.
Okay. Mr. Brodowitz, do the people waive their right to a preliminary examination today?
Yes, we do, Your
All
Honor.
right. I find the preliminary examination waiver to be knowing, voluntarily, and accurately made. And this case is to continue to circuit court. It's now bound over to circuit court. As charged. So please keep in contact with your attorney, Mr. Milks. He will provide you with a new date that you will need for circuit court. Your time in district court is done here. All right, sir?
Thank you.
Do they need to sign anything? All right. So. I don't know if it's the old or the new form, but
Yeah.
All right, so for the record, I'm signing the waiver for 3/24/2023. The waiver's been signed. Anything else for the record, docket 23-00642, Mr. Brodowitz?
Nothing from the people.
Anything else, Mr. Milks?
No, thanks, sir.
All right, Mr. Roberts, please keep in contact with your attorney, Mr. Milks. Your time in district court is all done. Thank you for your appearance today.
Thank you, Your Honor.
I think we're all set.
Yeah, that's it for me.
23-00777. That's People of the State of Michigan versus Michael Brundage. Will the parties please introduce themselves for the record?
Morning, Your Honor. Angela Delvera on behalf of the people.
And sir, oh, go ahead.
I'm sorry. Good morning, Your Honor. Peter Morris here on behalf of the defendant who was present and seated to my right.
Thank you. And sir, you are Michael Brundage?
Brundage, yes.
Brundage, okay. This is the time set for a probable cause conference today. Ms. Delvera, how are we proceed?
Your Honor, it's my understanding that the defendant will be unconditionally waiving his right to a preliminary exam, but before the court does that, Mr. Morris had a question of me this morning as it relates to bond. And when we went into the court file, there are actually several bond forms that are all signed the same day. I actually only had one of them in my file, so I didn't realize there were multiples. And it's a little bit unclear if they are meant to supplement each other or to replace each other, because the terms that change don't incorporate the terms from the previous order.
Okay.
So we sort of wanted the court to review them. I think Mr. Morris has a question about to what extent his client can access the internet, because it's unclear from the succession of orders.
All right. Yes, so let me see what's in the computer.
What happens is the PA 53, which is the bond conditions that are placed in the lien, is done ahead of time. So that document is separate from the actual bond paperwork. They look exactly the same. The only difference is really recognized by court staff. There's the bond conditions, and then there's the actual arraignment bond paperwork that the defendant has to sign to get out of custody. So my understanding would be that the last one would suffice, and he is not to use a computer except for during work hours for work purposes only.
Was that your question, Mr. S'mores?
That's part of it, Your Honor. Before I continue, I'd like to thank the court for allowing me to come in a little later this morning.
It's all right.
And it's just right now his mother's in her name has a flip phone. Technically, it does have access to the internet. He doesn't have an internet provider, but just communication with him is very. I have to either go through a brother who's might be working, and he's also in Pennsylvania. And the other day I needed to talk to Mr. Brundage. I had to literally drive out to his place because he just, because it was during work hours, so he couldn't use the computer. And so the only thing we're to the extent if it's allowed by the bond already, then I guess it's a moot issue. But if it's not, the court would allow him to just simply have a flip phone with the understanding that he cannot go on the internet and he doesn't have an internet provider. But it's just hard to find a phone that technically doesn't have some type of capability, quote unquote.
So I mean, so he would be texting you or texting. That would be the extent of the communication.
That'd be it. And I guess audio phone or texting,
right.
Yeah, with his lawyer only, even if
right. Well, Ms. Alvaro.
I think what I was looking for was to see if there's about 3 or 4 bond orders in the PA 53s.
You're looking to see which one is.
I was trying to see if it actually says he can't possess a device that accesses the internet, which was, I think, Mr. S'mores's initial concern. I don't think it says that. I think it says he can't use the internet. So I don't think that he's prohibited from having a phone that technically could access the internet.
Right, and my understanding of
He is.
Oh, he is.
The magistrate, one of the conditions that she free wrote on there was do not access the internet. I'm going to read you literally what it says. Do not access the internet. May use a computer only during work hours for work purposes, receiving emails, scanning documents, and making orders.
All right, so we can modify that so we can modify the pretrial condition, and then let me indicate what I'm thinking, and then you can go from there. I think since he can use a work computer through work hours, there's no modification of that because that seems to be the last condition. And then to be able to communicate with his lawyer or with his mother through text, I don't think do you have any objection to that?
I do not.
All right, so I think that would, that would provide some type of communication. So I would modify those conditions. That's the only modification, or I shouldn't say modification or clarification. I guess it is a modification if he wasn't. So that he can possess a telephone or cell phone for text purposes to communicate to communicate with his attorney. And then I would indicate with family members.
There aren't minors, because I think he's got a prohibition on contact with
Yeah,
minors.
so with family members that are not minors.
Thank you, Your Honor.
All right, with that understanding as to the nature of the pretrial modification, is your client prepared to waive today?
He is, Your Honor.
All right, all right. So may I inquire of Mr. Brundage of his waiver of his preliminary examination? No, I'll inquire.
Oh, okay.
Okay, so it is, it's my understanding today, sir, that you wish to waive your right to preliminary examination. Is that correct?
Yes, Your Honor.
Okay, you have a right to preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in this file. Do you understand that?
Yes, sir.
All right. You, of course, are represented by Attorney Pete Samoris, and he would be here to contest any charges and cross-examine any witnesses brought by the state in regards to these allegations. Do you understand that?
Yes, sir.
It is my understanding you wish to waive your right to that proceeding, that preliminary examination, and finish your time here in district court. This case would be bound over as charged to circuit court where negotiations would continue. Is that your understanding, sir?
Yes, sir.
Is it your wish to waive your right to preliminary examination today?
Yes, sir.
Are the people also waiving their right to preliminary examination today?
Yes, Your Honor.
I find the preliminary examination to be knowing, voluntarily, and accurately made. And your next date will come from Mr. Samoris, who's your attorney in circuit court. You won't get it here, but this case is bound over as charged to circuit court where the case will continue. All right, sir? All right, and I'll have you sign the waiver for the court file. And there might be a spot for the prosecutor now, too.
Yeah, I think if it's a new enough file, I think so.
Oh, bless. I don't see
Sometimes
it.
they used to be, where is it? It's in a weird spot right here.
Oh, there we go.
Yeah.
Yeah.
The new files have a place.
Yes, I
so-
see him now. Yeah, I see it.
Yeah.
All right.
All right, for the record, I'll sign the preliminary examination waiver, and Mr. Brundage, you should be all set, okay, sir?
Thank you, Your Honor.
Mr. Samores, were you at the doctor this morning?
No, I couldn't make it, but I'm gonna
Okay.
go back this afternoon.